This is Earl White, real estate attorney. This is a video about selling real estate in an estate in New Jersey, 5 key steps that you need to take. I have done many estate sales and helped many families sell property post-probate in an estate. And between the property condition, legal issues with the surrogate's court, hidden liens, there are critical steps to take during and before the sale process to ensure you don't have surprises that cost you the deal, money, or a great deal of stress. One of the first steps when conducting an estate sale is running a title search. You hire a title company and they will look at county records to determine what open liens exist, such as tax liens, mortgages, anything recorded in the county record to be resolved as part of giving clear title to a buyer, and also run name searches on the person who was deceased and also prior owners. It's important to run this in advance with an estate sale because the person who was the owner is now passed and they are not around. They may have had information that family members did not have, and people don't always share information with their family. So as much as you may think we know, there are probably things outstanding that the decedent wasn't aware of. They may have been older and maybe not as on top of finances and bills and legal issues as other times of their life. So run that title search, see what's out there, and some of it might be difficult or take time to resolve. This way, when you go to sell the property, you know what the issues are and you already have a head start on having it resolved. Or you'll do so at the real estate closing if it involves paying money you need for the sale, but you'll already know the process. So you can tell the closing attorney, this is what you'll need to do as part of the closing. A second critical step is understanding the picture regarding taxes. The reason this is that if the property is being inherited, there may be extra taxes. In my state of New Jersey, some members of a family are exempt, called Class A beneficiaries, which means that there is no estate taxes at the state level. That's such as spouses, direct children, or parents. However, if it's other classes of family members, say aunts, nieces, other people in the family tree, there may be no exception. And there could be capital gains owed on the amounts that that family member inherits. So you want to know this just the way when the people get sale proceeds, they don't spend it and not realize that taxes are going to have to be paid on it. Also, it's important to have this squared away when you're going into the sale process, because as part of the closing, title companies require an estate questionnaire. The executor or administrator of the estate has to fill in a 2 or 3 page document outlining the assets and what their relationships are. If there was going to be capital gains taxes due for clearing the estate, the title company will want to know that they've been paid off at the closing so it does not become a lien, and they may require an escrow to be withheld until those taxes are fully paid. So another good reason to make sure you know what the tax situation is. A third key step with regard to selling property in an estate is making sure the estate is fully probated before you begin the sale process. Oftentimes I've received deals from either the owners that come in or from realtors working with them, and the estate's not been properly probated with the surrogate court. The problem there is that no person truly has authority to execute a purchase and sale agreement, to execute a listing agreement, or to make and execute any other documents as part of transferring the property. The estate should be fully completed. It doesn't have to be fully completed, but the person should be appointed as an administrator or executor of the estate prior to executing listing agreement, purchase and sale agreement. Now, oftentimes, as a practical matter, maybe the deal does make it to the contract phase. Maybe the deal does make it to the contract phase before the probate is completed. In that case, the buyer may decide, look, even though the executor is not yet authorized to complete the sale, they'll go forward on the good faith that the executor will get their appointment before the closing and they will honor the contract, even though they weren't authorized when signing it. That can happen, and a lot of times that happens successfully. But the issue then becomes you waiting on the surrogate court approval. Sometimes that can be 2 weeks, but at least where I am in New Jersey, surrogate court approval could take months. So if a buyer has a rate lock, mortgage expiring, or they need to move into the premises, or there's some other specific time frame relating to the closing, the seller and buyer are at the mercy of the surrogate court, and that could take a very long time for a real estate sale. So the parties need to be committed. If the probate is not completed, the parties need to make sure they're ready to hold on a few months if needed for the surrogate court to complete the full probate process, because that will be needed before the title company will allow clear title to pass to the buyer. Fourth, it is very important that the family, all the stakeholders with the estate that have a share or interest in the property, are on the same page as each other. You want to start by taking a look at the will. If there are people that have a direct ownership interest, we're called direct advisees in the will, so they are receiving a direct interest in the property, they will have to sign off at the closing, and there's no way around that. So if the will said 5 people are entitled to 20% of a piece of real estate, all 5 of those shareholders will need to sign the deed and other closing documents. Therefore, if one of them is not in agreement, so if 4 people want to sell and one of the 4 that wants to sell is appointed as the administrator, you still cannot properly complete the sale because the 5th person who's not in agreement can pretty much not sign and stop the whole sale until they do. So very important to get all stakeholders on the same page. And even if they don't have a direct inheritance interest, the title company may also, even if there's no will, the title company may require that a spouse also sign off, even if they weren't directly entitled. So you want to get everyone on the same page to avoid any trouble, legal problems, disagreements during the sale process, so there's no last minute delays of the closing, which can happen when the family members, 2 weeks from the closing, 1 week from the closing, now it's time to sign the deed, and then people feel like they were cut out of the process. They didn't agree to the price. They didn't want this. And now we have a major problem on our hands because the seller has no right to immediately cancel the contract for that reason. The 5th key step I want to point out here is selecting an offer. With an estate sale, the properties often, not always, but often are in disrepair because 1, the person who owned it has passed away, so obviously they are not there doing regular upkeep. 2, the prior owner may have been elderly and not as active in maintenance of the property. And then 3, the family just, even if it's still in good condition, the family might not be in position to come out to the property and conduct repairs because they live somewhere else. So you want to pick an offer that understands the as-is nature. So it doesn't mean the buyer has to waive all their inspection rights, but they understand that the property is not going to be given substantial repairs as part of the process, in this way to avoid probably the deal getting canceled during due diligence in a few weeks. So pick a buyer that understands the condition of the property and accepts it. Again, not waiving their rights. They may still come back and ask for credits if there are unforeseen issues as part of the inspection, which brings to the next point for picking an offer is make sure it's priced strategically. If you know the property needs work and you get a very high offer, be ready. If things come up in the inspection report, you will have to give a credit or price appropriately that factors in that. You let the buyer know up front, hey, look, we're pricing it low to factor in the repairs we're anticipating. And then if they come up in the inspection report, that's an easy issue to resolve. Thank you for watching this video. If you need assistance with an estate sale in New Jersey, please give our law firm a call. We'll be happy to help out with it.